Okay, welcome back to another show. Now, in today's show, I wanted to talk about the latest news in regards to the upcoming Aaron Hernandez double murder trial. Now, we will be covering that trial when it starts in its entirety. Just to point out, Superior Court Jeffrey Locke set the date to January 19th. Hernandez, a former star tight end of the New England Patriots, is already serving life without parole following his first-degree murder conviction in Bristol Superior Court for the 2013 killing of Odin L. Lloyd in North Attleboro. In addition to that, Hernandez is also charged with committing the July 16, 2012 killings in the South End of Daniel D. Abreu. He was 28 years old, and Safiro Furtado, 29, both of whom he allegedly shot after being innocently jostled by one of the men in a Boston nightclub, prosecutors stated. Hernandez has pleaded not guilty to these charges. Now, I wanted to read a few things to you. Now, this is, if you're into the law, I thought this was necessary to read before I give my opinions on this, but I don't want to bore you with it. But again, I thought it was important to state. Now, Superior Court Judge Locke said he expected attorneys to fight over two motions that are sealed and have not been made public. The first, he stated, concerns evidence that is being held by a law firm that once represented Aaron Hernandez, that the Commonwealth argues is necessary to its case, but that it is not able to obtain without court order. Now, the second, Locke stated, concerns a request by the Commonwealth for the search warrant. Now, both motions, Locke stated, could affect Hernandez's Fifth Amendment right to self-incrimination and his Sixth Amendment right to a fair trial, and his right to seek confidential and protected legal advice and services, meaning, his attorney-client privilege. Now, Judge Locke, the defense attorneys, and Conley's office did not identify what physical evidence is that both sides are fighting over. So right now, they didn't make clear exactly what evidence that they need. I believe it's a cell phone, but don't quote me on that. And now they had a closed door session over this, but after that closed door session had ended, no one offered any public explanation to exactly what they were arguing about. Both sides were arguing about. But in January, the Globe reported that Suffolk prosecutors used a grand jury subpoena to try to get access to Aaron Hernandez's cell phone they believe was in possession of his attorneys. Okay, so that's what I was saying before. So they just stated here that maybe it was a cell phone or something like that. Now, the Supreme Judicial Court, in a unanimous ruling that did not mention Aaron Hernandez's name, said Suffolk prosecutors could not use the grand jury subpoena because it could violate the defendant's right to self-incrimination. And it went on to state that if a client cannot be compelled to produce materials because of the right against self-incrimination, and if the client transfers the materials to the attorney for the provision of legal advice, an attorney likewise cannot be compelled to produce them. Judge Barbara Link wrote for the unanimous court. However, Link also noted that nothing in the ruling suggests that a lawyer, having received materials whose contents are not themselves privileged for purposes of rendering legal advice, may retain such materials indefinitely, absent a continuing bona fide need and purpose related to the provisions of legal advice. Now, a lot of this is just legal information, but it's in regards to that cell phone, because the prosecutors in the double murder case, they're trying to get this cell phone. So basically, they're saying that they may not be able to obtain this cell phone. But let me just continue. In a concurring decision, Justice Robert J. Gordy wrote that the law was not intended to permanently shield from seizure unprivileged evidence of criminally activity placed in the hands of an attorney by a client under investigation, or to create a dispository for the sequestration of such evidence from law enforcement. Now, in addition, Gordy wrote that he thought the issue could be reconciled if prosecutors presented a warrant application to the judge outlining the specific circumstances at hand. If the judge concludes that no privilege applies to the item and that its retention by the law firm is no longer for the purpose of or necessary to the rendering of legal advice, the judge may properly order the warrant to issue, Cordy wrote. Now, this past Friday, and we just continuing here. This past Friday, October 23rd, Hernandez appeared in court Friday for a hearing called to question an anonymous tipster who raised concerns about the integrity of one of the jurors that convicted him of murder in his previous trial of Odin Lloyd. But it was not immediately clear to what happened. The courtroom at Fall River Superior Court was closed by the order of Judge Susan Garsh, and prosecutors and Hernandez lawyers would not answer questions about the proceedings, citing a gag order imposed by the judge. Now, Hernandez lawyers James Sultan said in a court document that an anonymous tipster called him several times after Hernandez was convicted. Sultan said the woman told him she worked with one of the jurors, and the juror was present for the discussion about the Boston killings. Now, the judge barred any mention of that case in regards to the trial of Odin Lloyd, meaning that, she barred the jurors from talking about this case to anyone. But Hernandez lawyer said, again, the tipster called them and said that this juror was discussing this information. Now, Sultan said that the woman told him, Sultan said that the woman told him raised the possibility that the juror was untruthful. The tipster and the juror have not been publicly identified. Now, in previous court filings, the prosecutor questioned the tipster's credibility and motives. They said she lied about her job and level of contact with the juror. They also said that she wrote Hernandez sexually explicit letters. let me read that again. I'm sorry. They also stated that she wrote Hernandez sexually explicit letters before and during the trial, and her father also served jail time with him. Hernandez lawyers had argued there was no downside in allowing a woman to be questioned under oath, and the judge allowed it. And that was the purpose of Friday's hearings. It's unclear when the judge will make her decision on how to proceed. Now, again, that's Judge Susan Garsh. She was the judge that was proceeding over not the double murder case, but the killing of Odin Lloyd. Now, she hasn't decided how to proceed. So we don't know if this particular tipster that testified under oath, we don't know if she's credible or not as of right now. So I can't even give an opinion on whether she's credible or not. But let me say this, if it's ruled that she is credible and there's some evidence there to support what she was saying, now, how is that going to affect his previous trial? I mean, will that be enough to grant him a new trial? I mean, he's already been convicted. He's already guilty. He's been convicted. He's a convicted killer. But would that be enough to grant him a new trial? And if so, would that, it's going to tie into this trial, because maybe this trial has to be delayed, but we don't know. But in my opinion, it doesn't seem like this is going to stick. Judge Susan Garsh, in his previous case, in my opinion, I thought she was very thorough in how she handled the case. Now, it's out of her control if one of the jurors talked to someone about the case. Now, is it possible that one of the jurors talked to their friends or coworkers about the case? Yes, it's very possible, even though they were told not to. Now, what I'm trying to figure out is, if she did talk to this person, did this particular juror, who they did not name yet, was she already under the impression, without hearing all the evidence, that he was guilty already? See, that's where the problem is going to reside in. If this is credible, did she already form an opinion already before the evidence was laid out to her? So that's the thing. If that's the case, it's very well possible that he can get another trial. And I don't know as far as what percentages. I think it's just I don't know. I really can't give an opinion on that, because we don't know the judge findings yet. She hasn't ruled this, so I guess to be continued on that case. So with all that being said, the circus of Aaron Hernandez continues, as we know. Again, we will be reporting on this story as it happens. I'll be reporting on both stories. I can't give much of an opinion on this latest case on the double murder because I don't have any evidence in front of me. Of course, the trial hasn't started yet, but when that does, I will be giving an opinion on that. I can't really say whether or not if it looks good for him, but I do know one thing. I can't remember the guy's name right now, but I think he's going to testify that he was there at the time of the double homicide. So if that's the case, it really doesn't look good for old Aaron Hernandez. I mean, he's already convicted killer in the previous case. He's trying to see, the thing is here, he's trying to beat that first case, and now he has another case going on. It's just it's just crazy. Just for someone to throw all that away to be in this position is just mind-boggling to me. But that's all I have right now. I would like to know your opinions on his double murder. Well, we all know that he was convicted previously. You can talk about that as well. And like I said before, I will cover, once she make a decision on how to proceed on this tipster, whether she's credible or not, I'll talk about that. I'll make a second video. But it looks like this trial, the double murder trial, is going to start in January. So we have some time between now and January. So if something pertinent comes up, I'll report on that. But until then, I would like to hear your comments on this and what do you think? Until next time, take care.